Thank you very much for the kind introduction. My PowerPoint is and remained work in progress, so it will just be here. Just you can see it, but I didn't quite get the scheme, so you will see what I'm talking about. But I'll just go through it anyway. So, distinguished Mr. President, honorable representative of organizers, dear colleagues, first of all, let me express my sincere gratitude to organizers for the opportunity to take part in the work of this conference. Its topic is important indeed, and I will try to shed light on one aspect of complex problems connected with the Constitution under extreme conditions, as it regards the example of Croatia and COVID-19 pandemic. So I will say a few words on regulation of the states of emergency in the Constitution of the Republic of Croatia, and on Croatian experiences of COVID-19 pandemic from the aspect of constitutional law. So Croatia adopted, you see, okay, this is the one. So the Croatia adopted its constitution, first democratic constitution, on December 21st, 1990. As it was adopted and promulgated just before Christmas, it is sometimes also referred to as the Christmas Constitution. Since its adoption, the constitution was amended on several occasions in 1997, 2000, 2001, 2010, and 2013. Now, the 1990 Constitution text regulated states of emergency in several provisions. Though Constitution revisions amended the original emergency provisions, and that especially goes for 2000, regarding the decision-making powers originally concentrated within the institution of the President of the Republic, there are, however, significant similarities in comparison of original with current, with valid constitutional articles that regulate states of emergency. The Croatian constitutional framework for emergency situations in general follows the well-known pattern, we might say. Namely, these norms enable the government to restrict or to suspend certain constitutionally guaranteed rights and freedoms, as well as institutional mechanisms of checks and balances, to concentrate decision-making in central governmental bodies, so allowing executive bodies to take those actions that will, in the end, terminate the temporary state of exception and restore a state of normalcy. Now, the original 1990 Croatian constitutional framework was partially modeled upon Article 16 of the French Constitution, that's Constitution of the Fifth French Republic, 1958, and such are also two valid provisions of the constitutions that directly regulate emergency measures. One is Article 17, and the other one is Article 101. Interestingly, the Croatian constitution does not use the term or exact term, the state of emergency, but Articles 17 and Article 101 differentiate between four types of such extraordinary situations. First is state of war. Second is clear and present danger to the independence and unity of the Republic of Croatia. Third one is event of major natural disaster. And the fourth type is the event in which the government bodies are prevented from regular performing of their constitutional duties. So it also follows from the provision in Article 101 that two situations are basically set as alternative conditions. In other words, that the existence of clear and present danger to the state does not necessarily mean that government bodies are prevented from performing their constitutional duties. So it is interesting to point out that all four types of emergencies were enacted already in the original text of the Constitution in 1990. As it regards the Croatian example, the constitutional norms in Articles 17 and 101 demonstrate that the competence of enacting emergency measures is divided between the legislative and the executive branch of government. First, in situations where the measures restrict individual constitutionally guaranteed freedoms and rights, it is the legislative body, in other words, Croatian Parliament or Hrvatski Sabor, that has exclusive power to enact such measures as long as it is able to convene. The President of the Republic is authorized to act, but only if the Croatian Parliament is unable to convene upon the previous proposal of the government and with the counter-signature of the Prime Minister. In accordance, and that's second, with Article 101, the President of the Republic is authorized to issue decrees with the force of law, but on the ground and within the limits that are previously delegated to it by the Croatian Parliament, and only if Parliament is not in session, then the President of the Republic is allowed to regulate all issues required by a state of war or some emergency situations. Now, coming to limitations of fundamental rights. We might say that the very notion of the state of emergency is based on two requirements. The first one would be the concentration of powers. The other one would be limitations of rights and freedoms. Now, Article 17 of the Constitution provides that during a state of war or an immediate threat to the independence and unity or major natural disaster, constitutionally guaranteed human rights and freedoms may be restricted. Such derogation shall be imposed by the Croatian Parliament by a two-thirds majority of all members. That is also a majority required to adopt a constitution, for example. Of course, the procedure is a little bit different then. So, therefore, the power of imposing restrictions on human rights during emergency situations is primarily vested in hands of legislative body. In other words, it is exclusive as long as Parliament is able to convene. Only in case that it is unable to convene, then it can be regulated by the executive, by the President of the Republic, with counter-signature of Prime Minister. So, this is important. In normal circumstances, laws that elaborate constitutionally guaranteed human rights are passed by a majority vote of all representatives. On the other hand, in emergency situations, such parliamentary decisions must be passed by two-thirds majority of all representatives. Furthermore, and this is quite common, when deciding upon restrictions on human rights, some important criteria must be respected. First, that would be principle of proportionality. Second would be a non-discrimination principle. And the third fact, final, is there are some rights that are absolute, meaning they cannot be restricted or derogated in any situation. So not even in cases of clear and present danger for the Republic. This is classic state right to life, non-discrimination clause, etc. So, what about experiences of COVID-19 in Croatia from the aspect of constitutional law? Now, in search for the legitimate action to combat the pandemic, a state of emergency in Croatia was not declared. It was the executive branch from the start, in other words, the government, that took the initiative, so from the very beginning. Now, pursuant to the law on civil protection system that regulates basically civil protection network in Croatia, the civil protection headquarters was established as an expert operational body, and the Minister of Interior was appointed chief of the headquarters. Furthermore, the minister, so that's the first law. Furthermore, the Minister of Health declared a COVID-19 pandemic in the Croatian territory pursuant to the law on the protection of the population from infectious diseases. This is the second law. So these two acts, bills, laws, were used as a normative framework to prevent the spread of the disease. And the Croatian Parliament soon amended it, this framework, and it has been done in an urgent or expedited procedure, giving the headquarters very broad powers to adopt decisions and guidelines to manage the pandemic. Now, of course, the headquarters now were authorized to enact special emergency epidemiologic measures, which are otherwise enacted by the Ministry of Health. Headquarters must act with the cooperation with the Minister of Health and Croatian Institute for Public Health. That was on the paper. In fact, in practice, it was the headquarters that enacted all measures such as quarantines, travel bans, wearing of face masks, restriction of movement, etc., etc. So the executive response to pandemic led by the Croatian government provoked lively public debate in which several problematic issues were highlighted, and they were challenged. Yeah, they were challenged, this was the last one, before the Constitutional Court. Now, first, such actions provoked criticism based on the argument that, according to law, only the Minister of Health and not the headquarters was authorized to order emergency measures. Second, since the constitutional emergency framework was not activated, the COVID-19 crisis was totally managed through or inside the legislative framework. So, anti-epidemic procedures foreseen by law on civil protection system and law on the protection for population from infectious diseases. Now, both laws that served as the basis for conducting decisions and enacting different measures were adopted following procedure stipulated not by Article 17, but by Article 16 of the Croatian Constitution. Unlike Article 17, which regulates the emergency regime, which provides for laws concerning human rights restrictions to be adopted by a two-thirds majority, Article 16 enables the restriction of fundamental rights, fundamental freedoms, but in normal circumstances, following standard legislation-making procedure provided for a specific kind of laws. So, consequently, a number of related constitutional complaints and constitutional review proposals were submitted. Deciding on the merits concerning aforementioned and similar objections, the Constitutional Court, in its decision, inter alia confirmed that the executive body, that's headquarters, adopted decisions on restrictions of human rights, and it was legally entitled to adopt such measures based on the legislative framework adopted previously by the Croatian Parliament. The Constitutional Court also held that as headquarters operated directly under the supervision of the government, decisions adopted by it are undoubtedly subject not only to the control of executive, legislative, and judicial authority, they are also subject to constitutional control or control of constitutional court as well. However, according to the court, headquarters remained within the limits of its powers as prescribed by the Constitution. And furthermore, and this is probably the most intriguing or most interesting question as it comes to constitutional law, at least, the Constitutional Court of the Republic of Croatia confirmed that Croatian Parliament may adopt derogatory measures based on two constitutional provisions or based on two regimes. Article 16 in ordinary times and Article 17 in emergency situations. However, Constitutional Court decided or concluded that it's not up to the court to decide whether the Parliament should, in certain extraordinary circumstances, activate Article 17. In fact, to decide whether the COVID-19 pandemic qualifies as major natural disaster that should trigger our emergency constitution, because it should. Or such derogatory measures could be adopted in application of Article 16 that allow restrictions of rights and freedoms in normal times. So basically, what the Constitutional Court said is the choice between the application of Article 16 and Article 17 is exclusive domain of the Croatian parliament as a legislative body. This competence, it is so because this competence was transferred to it by the constitution itself. Constitutional Court also confirmed its standing in several later cases. It decided upon the constitutionality of different anti-epidemic measures, such as restrictions on public gatherings, sport activities, mandatory wearing of face protection masks, etc., etc. So, basically, to conclude, it is evident that the Constitutional Court decided supportively of the executive and legislative approach towards the anti-pandemic combat in prevailing majority of cases. That's it. Thank you.